To interrupt for a second, I'm going to bring in Congressman Van Hollen in a moment. You say you are investigating him for possible perjury. What could Holder say that would satisfy you, that would clear up this clear discrepancy?
Well, I think in fairness to the Attorney General, I'm not going to second-guess what he will tell us, nor will I second-guess, and I need more information about what exactly his involvement was with the issuance of the search warrant with regard to the Rosen matter, which of course wasn't even the subject of the hearing. That was focused on the AP matter. It was only when a federal judge recognized that this sealed warrant had been held an additional 18 months, or nearly 3 years beyond when the warrant was issued, that this became public since the hearing. So this is new information to us, and we want to hear from the Attorney General in response to what you point out is a clear contradiction between his statement and the facts as we know them at this point.
Congressman Van Hollen, same question to you basically. How do you reconcile Holder's testimony under oath to the committee that he had never heard of, was never involved in, not the prosecution, but the potential prosecution of a reporter, with the fact that he signed off on the request for a search warrant that spoke specifically of James Rosen's potential criminal liability?
Well, first, Chris, I'm glad the chairman's going to give the Attorney General an opportunity to respond here. Here's how. These are perfectly consistent, and it is often the practice in cases where you have investigations that you target somebody for the purpose of gathering information with never having any intention of prosecuting them. And what the Attorney General said is that it was not their intention to prosecute Rosen in this case, but that doesn't mean that they shouldn't try and seek relevant information to a case where we know that important top secret national security information was disclosed that potentially compromised our sources and methods in North Korea. Let's remember what happened was you had a contractor at the State Department, Stephen Kim, who gave information to Rosen.
Allegedly gave information.
Allegedly. The FBI apparently went after Kim and got his records, but there was some missing information that they were seeking, and that's why they went to a federal judge, an independent judge, and an FBI investigator under oath filled out an affidavit seeking information as part of their case against Stephen Kim.
But the fact is that the FBI investigator, Mr. Reyes, who signed off on this affidavit, did it, we are now told, the Justice Department has admitted, with the approval of the Attorney General. And it isn't that they went to one judge, they went to 3 judges before they got one who would agree that Rosen would not be notified of this. You don't think that that's in any way signing a false affidavit, which I must tell you, sir, is also perjury?
Yeah, it would be. But tell me what's false in the affidavit. There are no false allegations that are made in this affidavit that I know of, and certainly I don't think Chairman Goodlatte has any information about false allegations in this affidavit.
The Attorney General says...
Well, Chris...
Go ahead. I'll let Chairman Goodlatte...
Chris,
what's the false information in the affidavit?
Well, the false information is that they found probable cause to find that he was an aider, abettor, or co-conspirator with the alleged leaker of the information. Therefore, when the Attorney General says that he'd never heard of such a potential prosecution, it raises the question either the Attorney General is not being truthful, or the Justice Department has a lot to answer for in using allegations with regard to an individual to get a search warrant that they would not otherwise get unless they indeed could show they have probable cause to find that to be the case.
I mean,
I'm going
to ask you about that directly. Attorney General Holder says in his testimony to Congress with regard to the potential prosecution of the press, never heard of it, never involved in it. The search warrant talks about James Rosen's potential criminal liability. Potential and potential.
Yes, but the Attorney General and the Justice Department always have the discretion not to bring a prosecution or criminal case. And as the Attorney General said, it's their policy, essentially, not to bring that kind of case. That does not mean it's not true as a legal matter to allege exactly what they alleged in this affidavit. After all, as we know, there are lots of facts in this case. The fact is Rosen and Kim set up these alias names, special email accounts. But that doesn't mean that the Justice Department ever intended to criminally prosecute Rosen. I mean, not at all. I mean, people fill out affidavits as part of cases where they're trying to collect information.
I think
in these kind of cases.
I think we plowed this ground. Let me move on to another subject, and you can get back into this in your answer, Congressman Goodlatte. Congressman Van Hollen, you say that some Republicans are using the Holder case to distract from the real issues of the economy and jobs. Do you not think that the possible infringement of First Amendment rights of reporters is a real issue?
Oh, of course it's an issue. The issue is, how do you balance our legitimate national security needs with our First Amendment rights? You've got to admit this whole thing reeks of hypocrisy, Chris. It wasn't that long ago you had Republicans on Capitol Hill and a lot of folks on Fox going after the Obama administration saying, you're not getting to the bottom of these national security leaks. It was nonstop for a while. Then the administration goes after these national security leaks and people say, oh, you can't do that.
No. Well, in fairness, that's not what people said. People said you can't talk about a reporter as a potential co-conspirator. Let me ask you a question as a lawyer. How many times has the Justice Department successfully prosecuted or even tried to prosecute a reporter under the 1917 Espionage Act?
Oh, I don't think they have. And
so
the point
whose hypocrisy are we talking about?
No, and the point is the Attorney General is saying they weren't planning to prosecute this reporter either. That's the whole issue here, that they were never intending to prosecute him. They were trying to collect information in a case that involved the leak of important national security information that compromised sources and methods. I think it's perfectly legitimate, once they exhausted their search of Kim, who was the target, that they collect additional information for the prosecution against Kim, not Rosen.
Congressman Goodlatte.
Chris, if I might add, the information submitted to the judges indicated that Mr. Rosen was considered to be a flight risk. Well, how would he be a flight risk in the mind of the Justice Department and the officials pursuing this matter if they did not have a potential prosecution, an intent to prosecute him when they went and requested this search warrant? They would not have received the search warrant if they had not said that he was a potential
flight risk,
a target of this investigation, and therefore you have a real crossing between First Amendment freedoms and overzealousness on the part of the Justice Department. It is important. I agree with Chris Van Hollen. It is important to investigate leaks, and we have always said that, and we'll say it right now. But I would argue that in both the mishandling of this case and the AP case, the Justice Department has damaged their ability to investigate leaks properly because they haven't followed the rules, and in this case, the Attorney General has to answer for it in particular.
Gentlemen, I've got to break in where we've got only a couple of minutes left, and I want to get to one more question that I think you'll both agree is very important. This month, the Senate is going to consider a comprehensive